Good afternoon, everybody. It is 2 o'clock, and welcome to Public Rights of Way Greens Committee EGM. Good to see many members of the public. Thank you for coming, and I'm delighted to see all our members are here as well. Thank you for coming, especially as it is an EGM. I know it's an extra call upon your time, so I'm grateful that you are here. In terms of the safety regulations, I think you probably know them by now, but if there is a fire alarm, there is no fire drill, so they've been planned, so please do leave the way you came in, and we assemble outside the cathedral and we pray for salvation. The other little plea from me, mobile phones, I appreciate you might want to leave them switched on, but silent, please, silent. Otherwise it will be a major distraction for us. Agenda item number 2, apologies for absence and substitutions. There are none. Agenda item number 3, declarations of interest. I will declare, obviously, that I am the ward councillor in which this area sits, but I don't have a pecuniary interest. Are there any other declarations of interest? No. Okay. Agenda item number 4, public forum. And we will take statements first, and then we'll go on to questions. So, public forum statement number 1 is from Helen Powell, if Helen is here. Yes.
Thank you. We're here today because you've been asked to assert and protect the public rights of way at Stoke Lodge, which is a statutory duty. The courts are clear that it's a duty that you cannot refrain from exercising, and that you must act in the interests of the public who want to use the paths, not a developer who's obstructing them. At the last meeting, officers talked about the Gaia case and said it was an exception to that duty, but that's wrong. The duty is absolute. In the Gaia case, the authority had held a public inquiry and determined that a right-of-way did not exist, but they were being asked to assert it anyway. That's not the case here. You made a unanimous decision based on overwhelming evidence and an expert report, and in full knowledge of Cottam School's objection that they do exist. The Stoke Lodge rights of way are supported, not disputed by the council. An objection has been made as part of the DMMO process, but it doesn't have any more weight now than when you considered it before. Now we need you to take the next step and assert those rights by instructing the council's tenant that the routes must not be obstructed. Officers are now saying that if at a later stage this went to the magistrates' court, they would try to argue against your decision. That advice comes from the same legal officer who thought it would be a good idea for the council to sue itself over Stoke Lodge 2 years ago. Lessons have clearly not been learned. But that's a decision for another day. For today, it's pure misdirection. The legal advice is just advice. We don't know what questions were put or what information was provided, so we don't know how sound it is. But the final decision rests with you. The advice you've been given is about Section 130B of the Highways Act. We're not in Section 130B, and we may never get there. We're in Section 130A, which was added in 2004 specifically to make it easier for members of the public to ensure that Section 130 is enforced. That's your statutory duty to assert and protect public rights of way. Neither Section 130 nor 130A mention serious disputes at all, and they make clear that rights of way don't have to be on the map yet to be rights that you should assert and protect. There is no exception, and we're nowhere near the circumstances of the Gaia case. The question today is not what a magistrate's court might do in the future, but what you should do now. And that's clear. You should order Cottam School, which is, after all, the council's tenant, not to obstruct them. If your tenant refuses to comply, that's on them. Let them be shown up for their poor conduct, not you. This committee should uphold the law, not bow down to bad behaviour on the part of Cottam School. Doing the right thing in this instance is free. Thank you.
Thank you for your statement. If I miss anybody who's on the list, do let me know at the end. But I've been advised of who wants to speak, so that's the people I'm calling at the moment, okay? So, Stephen Devlin is next on my list.
Somewhere.
Not here, okay. Robin Parker. Anna Capel.
I'm aware that Helen said it's an argument for another day, but I'm going to go there today, I'm afraid. I've got a feeling of deja vu, really. We've been here before. When Cottam School challenged the town and village green registration, His Honour Judge Paul Matthews made it absolutely clear that Bristol City Council is one corporate body. It cannot, in his words, split itself like an amoeba or suck and blow at the same time. Yet that same pattern is at risk of repeating now. Last November, this committee, after a thorough, intelligent debate based on detailed evidence, agreed unanimously that 4 public rights of way do exist across Stoke Lodge. Such decisions are legally made by this fully delegated regulatory committee on behalf of the whole council. Officers are now advising you not to enforce on the ground that there's a conflict in evidence and to wait until Planning Inspectorate makes a decision. But the High Court's ruling made it clear that the council cannot legally undermine itself by taking 2 sides of the same argument. Members must be wary of administrative games that try to present committee decisions as provisional and not lawful, which they are. The whole council should be working together to preserve the integrity of their decision-making. This committee made a definitive and unanimous decision by proper process. The council must act coherently with that finding until and unless new evidence is publicly disclosed and subsequently agreed to affect the ruling. Thank you.
Thank you. Susan Mayer is next on the list. Is Susan here? Yeah.
Just speaking to it, yeah. Just angle it towards you.
For decades, Stoke Lodge was a shared space for local schools and the community, with mutual respect for each other and the parkland environment. There was never any issue prior to Cottam Academy's lease that warranted fencing to the extent we now see. In closing off all access to Stoke Lodge playing fields, Cottam deny the simple rights and pleasures other communities take for granted, such as a kickabout for active kids, a stroll with a baby in tow for young mums, a peaceful walk for the elderly, perhaps infirm, or simply a meet-up place for those living alone, and not forgetting those taking a well-earned lunch break in the fresh air. There are many examples of school sports facilities that are largely unfenced. King George's playing field in Down End is one that mirrors Stoke Lodge. The local school happily share open parkland with children's play area where the public walk their dogs over pitches to no adverse effect. Please note this really is the last green space in Stoke Bishop, and there is nowhere within suitable walking distance that could replace this vital green oasis. Cottam could do the right thing and only fence a small area they actually use. However, widespread rumours suggest a hidden agenda to commercialise the site or simply to sell off parts of the field for housing. But the children's play area stands in the way, and any new vehicle access is hemmed in, and stands in the way of any vehicle access in this hemmed-in parkland. So, could this be why Cottam has refused to release this area from their lease for more than 11 years? Would someone in authority please put an end to these rumours and confirm that no area of the parkland would be earmarked for development if the school chose to relinquish their lease at any time in the future? Thank you.
Thank you. Judith Brandt.
No.
No. David Mayer is next on.
Good afternoon. I hope you've had time to review my statement, in particular the YouTube video recording the meeting of this committee, where you rightfully and unanimously voted to confirm the public rights of way at Stoke Lodge and confirm that they did exist. Whilst the minutes of that meeting are utterly inadequate, this video demonstrates the true level of scrutiny and rigour of debate the committee engaged in. Importantly, this includes all the objections raised by Cottam. In short, your decision was robust and just, contrary to the decision being forced on you now by legal services. I therefore urge you to insist that public rights of way are preserved and protected until the Secretary of State rules and confirms that the public rights of way do exist. Or are we going down the road of the post office? Can I finally reconfirm it is not for Cotton to decide where public rights of way are or whether they exist or not. That is a decision for the Secretary of State and should be left for him to decide. Thank you.
Thank you. Professor Alan Preece.
Thank you, Chairman, and thank you, Committee. I had originally not intended to add any words to my written statement, but in the week since that was written, a lot has changed and become apparent. I was very puzzled that Cotton were confidently spending a huge amount of money progressing the fence on much of the original footprint. So I was wondering whether Cotton had either forewarning from the Secretary of State that they were not going to agree to the registration of the paths, or whether they already knew that Bristol City Council would allow significant diversion. I now know from a public statement by Cotton yesterday that they are in the process of diverting paths 683, 685 and 686, two of them along Ebenezer Lane and Parry's Lane, and one to the outside of the fence in the other direction and past the play park. Cotton have also installed lockable gates on the particularly important route from West Dean to Shirehampton Road. And this is a route that was strongly supported in the one objection letter for, I believe probably on behalf of Coombe for students walking from the number 4 bus on Shirehampton Road to get to Coombe. And it's a particular pity that the 683, 678 pathway, which goes from Charing Road to Druid Hill, is being diverted, as it's been for many years on the Ramblers Association website as part of the Walk Bristol route to Blaze, linking up with other public rights of way into Bristol Centre. I can only assume that Bristol City Council legal services officers have authorised this change, and I'm somewhat disappointed I had to hear it from public pronouncement from Cotton yesterday. It's also contrary to the decision of the committee last year to approve the paths. Thank you, Chairman.
Thank you. Peter Weeks. Peter Weeks here. Shirley Brown.
Thank you. Contrary to Cotton School's public statements, they've acted, putting up the fence again, without communication, much less consultation with neighbouring residents. I am shocked by Cotton School's misleading claims about the effects of the High Court judgment on the TVG and the way in which legal officers keep presenting the case. Despite this week's hostile action, preempting this committee's decision today, erecting lockable gates that are much narrower than the agreed width of a public right-of-way, across particularly the Chain Road entrance, which leads to 3 of the 4 claimed rights-of-way. The school refers to the council's statutory duty to consider how its decisions and actions affect people with different protected characteristics, but they make this apply only to their school pupils. What about the different protected characteristics of my community? Thank you.
Cathy Wellen. Sorry. Number 59 is Sandra Fry. Sandra Fry.
Thank you. I'm sorry we have to stand here again and talk about a matter of community campaign challenge to Cotton School. I'm sorry that there are only 2 representatives from the school here. We have taken the judgment some time ago to run this, to manage and respond to the campaign and the challenge honourably, properly and always in line with the law. And to that end, we are more concerned that our students go to school than come here and stand in front of this committee, so please forgive me that. We're here to represent a very large school in Bristol, 1,700 young people. I share the lady's concern about protected characteristics and we should consider everybody. But perhaps in this report it doesn't really consider anybody, because our 1,700 young children and their parents and their carers and students who went to the school before care that these are education school playing fields. The High Court has said that, and these public rights of way that you are considering enforcing do not exist in our mind. They are seriously in dispute. You have in front of you the statement we produced yesterday. Every time we produce the statement, someone attempts to turn it into something else. It was an honourable attempt to say, we've worked out a plan, we'd like to talk to people, but every time we talk to people it gets twisted. So please, give me the respect that I asked last time, you'll do it again today. This has been an incredibly challenging and difficult campaign for me personally, for Alison personally, and our head teacher. Our head teacher is away today on Ofsted work. You know she's an Ofsted inspector. She knows how to run this school brilliantly, sometimes scarily, and these playing fields are so important to our students. So I'm not reading my statement because this has come from the heart. Please do not attempt to enforce these footpaths in front of you. I'm sorry that it has to go to PINS and there appears to be a long wait. We have drafted, I'm not sure if the letter's actually gone, letter to PINS to ask them to speed up. The council can do the same. We did give you the option in June to reconsider whether these public rights of way can really exist, because now that the High Court has found there is no TVG and the Appeal Court said it cannot be challenged, there cannot be any public rights of way across our fields. And I'm sorry to the campaigners that this is a saga that's coming to a particular point and we need to find a way to work together. But please, members, do not enforce these footpaths across our fields. Thank you.
Thank you. Emma Burgess.
Sorry.
Thank you. Good afternoon, councillors. I'm also not going to read from my statement. I hope you have had the opportunity to do so. Many of my community members have said the same. I was shocked when I read the recommendation from your officers, but I don't know why I was shocked, because this isn't the first time that you have received incredibly challenging advice from your legal officers. We've already talked about splitting themselves into and becoming an amoeba. Quite frankly, as is our expert legal advisor, very shocked at the recommendation your officers have given you. In short, the legal advice you get depends on the question that you ask. Have you, as councillors, seen a copy of the instruction? I certainly know that I would like to. Please rest assured, it is in the public domain. It is on legal record. Judge Matthews did not make any determination about those public rights of way. In fact, he said they were established. Town and village green law is incredibly different to public rights of way. They are two completely separate matters, and the outcome of the High Court case has absolutely no bearing on the four public rights of way that this committee granted using independent expert advice from an inspector that said it was overwhelming rights established at Stoke Lodge. We're not even at the stage of a legal dispute at the moment, but under section 13A of the Highways Act, you have a statutory duty to assert and protect these public rights of way. It doesn't matter about the PINS, it doesn't matter about the Planning Inspectorate. You have that duty today. Just because the tenant doesn't like it, and just because officers are scared of legal threats, that doesn't make any difference. If Cotton School continues to obstruct public rights of way, let that be their problem, not yours. Don't let this committee break the law to protect the school. Please uphold your duties. Please uphold these rights. And ask yourselves, why have these officers given you this advice at all? It seems to me that they're more afraid of winning a legal battle with the school than of losing a legal battle to the public they are meant to serve. Thank you.
Thank you. Cathy Wellham.
I just want to say that I share the shock of the rest of the community, and I share the amazement that this school can go ahead and try to cut out the heart of the community, which is held together and has been held for years, connected and woven together by these rights of way, which people traverse and chat on and go along, go to the shops on, and use as the fabric of their community. This has been built on for years and years, over 70 years. And for the school to say that it doesn't exist, and for the school to say that the High Court judgment in any way affected that, is a complete nonsense. And I wish the school would start to behave itself.
Thank you. Alison Crossland.
Thank you. I'd just like to start by saying it's probably very difficult to be in these situations to make a decision. And I guess my position at the school means that I will always seek legal advice, because that's always safe to use in your decision making. So the alleged public rights of way are incompatible with the June 2025 judgment. The legal status was confirmed by the court. It definitively established that Stoke Lodge constitutes private school playing fields for the education of our 1,650 plus students. This legal status is fundamentally incompatible with public rights of way. Key incompatibilities. Direct legal contradiction. The court confirmed these are private educational playing fields, not public open space. Public rights of way would create permanent legal rights that directly contradict the court's findings, undermine the private educational status the judgment established, effectively convert private educational land into semi-public space. Safeguarding requirements. The school has statutory safeguarding duties towards its students. Public rights of way would create uncontrolled access routes through areas where children are engaged in educational activities. Prevent the school from maintaining a safe, secure environment as legally required. Make it impossible to control who has access during school use. Expose students to risks the school cannot adequately mitigate. Educational use and operational control. The court recognised the school's right to use the fields as necessary for educating its students. Public rights of way would compromise the school's ability to timetable sports, PE lessons and outdoor education. Prevent exclusive operational control necessary for educational activities. Create insurance and liability issues when public access crosses active playing areas. Undermine risk assessments and school emergency procedures. Permanence and precedent. Public rights of way cannot easily be extinguished once granted. Agreeing to them would set a precedent requiring private educational facilities to accommodate public access, potentially compromise future educational development of the site, create expectations fundamentally at odds with the school's educational mission. Conclusion. The June 2025 judgment was clear. Stoke Lodge is private educational land held for the school's students. Public rights of way would directly contradict this legal status, compromise safeguarding obligations, and prevent the school from fulfilling its educational mission. This is not a matter of preference, but of legal necessity, following the court's definitive ruling. We remain very committed to working constructively with Bristol City Council to ensure our playing fields serve their intended educational purpose effectively and responsibly. Thank you.
Thank you. We're going to move on to questions, but we only have 5 minutes left of public forum, so apologies if my answers are a little bit brusque to supplementaries. So Question number 1 is Mr. Adrian Dobrovic, if I've pronounced that correctly.
That's fine, will do. Yeah, I'm disappointed in the answer I received about an hour ago, so I'll ask the question again slightly differently. Does the council have any intention to support and uphold community use of any area of Stoke Lodge, even those areas where Cotton School has no intention of using? These areas fall outside the current boundary fence, and access has been deliberately blocked in several areas. I guess that's Cotton School's way of reaching out to the community. I interpret this as a true level of respect the school has for the local community. So do you intend to support community use of areas that fall outside the boundary fence as well as those public rights of way?
Thank you for your question. I'm afraid that really is a question for Cotton School rather than myself. What I do know is that the council does hope to organise some mediation between the school and residents. It has been attempted before. Third time lucky, as they say. So I do hope that we can sit down and we can agree something. Because I think your question was talking about beyond the fence. That's right. The perimeter walkway, which has fallen into disrepair. That's right.
Outside the fence, the blocked off by the school to prevent local access. So outside of the fence, and surely that shows something about Cotton School's true.
I think you do need to enter into a dialogue with the school. I think that would be very helpful. Question number 2, Helen Powell.
Thank you. I do have a supplementary, just having heard what's been said today. Is the committee aware that the 2 public statements from Cotton School are specifically misleading you about the High Court judgment? The judge says in terms that he is not dealing with the issue of public rights of way because they are a separate matter from TVG status. The decision is not, as has been said, fatal to the rights of way. In fact, he very clearly said that the school's lease is subject to any public rights of way across the land, whether or not they are recorded. And he made clear that the community's use of the land is not by permission under the lease. The bit that Miss Crossland put in quotes doesn't exist in the judgment. Ashton Park School, for example, has a well-used right-of-way across its playing fields on its main site and isn't making any kind of fuss about it, so you have to question why Cotton thinks it can risk committing a criminal offence by obstructing the rights of way at Stoke Lodge. Lots of schools have public rights of way across their land. Are you aware that those claims are not true?
I think that's something that we will debate as a committee, and what we do understand is that Town and Village Green law is quite different from public rights of way, and the time periods are different, and we do have legal advisors who will clarify that position for us. So thank you for your statement, for your question. 2 minutes left. So, Lydia Sheehan here. Robin Parker. Ian Woodward.
Thank you. I'd like to ask a supplementary, and it goes back to the High Court. We have seen that you are taking legal advice from the very same department that tried to go against its own elected councillors, who lost a lot of essential evidence that the We Love Stoke Lodge campaign had put together, and finally, and most importantly, that a senior legal officer on the list to attend today, although she's not here, attended the High Court in direct contradiction to the statement, the position of the council. How clear are you that the advice that you are receiving is untainted by bias?
I don't think I can really answer that question. What I can say is that I've worked for over 40 years with lots of advisors, and I'm aware that advisors are often venturing their opinion. So I take advice with a pinch of salt. I think advice is normally well meant, but not always accurate. That's just the way it goes. But thank you for your question, Ian. We're out of time, actually, but I will just comment on question 7 from Susan Mayer. You have had an answer which says this matter is being progressed. You've been sent, I think, I've just had confirmation from Democratic Services, you have been sent another answer which is different. Now you may want to pick that up offline with myself and Democratic Services, and we can then dig into the detail of that. Okay, thanks very much for your contributions. That's been really helpful. Agenda item number 5, which is the meat of the matter, Stoke Lodge Highways Section 130A notice enforcement. Before I move on to that, I do have some good news on this rather gloomy afternoon when you look at it. Officers have been chasing the Planning Inspectorate to get a move on, because at the moment we haven't had any date. But the good news, and thank you to the officers, is that the Planning Inspectorate have confirmed they'll be writing out to all parties in the next few weeks. And I think the initial letter is, how do you want to take this forward? Is it going to be an inquiry or whatever? And that's a good sign. It still doesn't give us a definitive date, but the fact that the ball has started to roll probably means we're talking months rather than years. So that is, I think, very good news. Thank you to the officers who've been pushing and prodding the Planning Inspectorate, which is by no means easy. As you know, it's a big organisation. Other little things as we go on to the meeting now. This is for members as well as members of the public. If you look at page 9 of our papers, particularly the last paragraph, I think it's clear that there's a distinct possibility that one way or the other this may end up in court. If we don't enforce the notices, Helen Powell could take the matter to court. If we do enforce, Cottam School have already said that they may commence legal action to stop or delay enforcement of the rights of way. Which leads me on to the next bit, is because it is a complex legal matter with the threat of litigation, we have, or the council has obtained external legal advice, but that is subject to legal privilege. So if we have to start debating the external legal advice, we will have to move into what's called an exempt session. We will move, the public, you're welcome to stay put. We will actually move to a separate room. And Nancy Rollinson, who I think most of you know as the head of legal services, will actually give me a big kick. No, she will explain if we are straying. We're going to try and keep this meeting in public for as long as we can, because I don't like exempt sessions. Everybody gets very suspicious and wonders what on earth are those councillors talking about? What on earth is going on? So, as far as possible, we're going to keep this meeting in public, and we're going to start off with Duncan Venison is going to introduce the report and explain the statutory duties imposed on the council by section 130 of the Highways Act. And he'll also cover section 130 subsection 7, which offers some protection to the council with alleged rights of way as well as proven rights of way. Duncan, over to you.
Thank you, Chair. The report before you covers the background of Stoke Lodge playing fields, which you're all well aware of. The report goes on to provide an update on the state of the fence around Stoke Lodge as at the 10th of October, and then discusses the notices served on Bristol City Council under Section 138 of the Highways Act 1980. Section 130 of the Highways Act 1980 places a duty on the Highway Authority to assert and protect the rights of the public to use and enjoyment of any highway of which they are the Highway Authority. Section 137 provides that any action taken by the Highway Authority in relation to an alleged right of way will not be treated as unauthorised if that alleged right of way is later found not to exist. Section 138 allows for a person to serve notices on the Highway Authority to request that they secure the removal of obstructions across certain types of highway, including a footpath. The Highway Authority is given 1 month to serve notice on any person responsible for such obstructions. Section 130B goes on to say that if the person who serves the Section 138 notice is not satisfied that the obstruction has been removed, they may apply to the Magistrates' Court to seek an order requiring the Highway Authority to secure removal of the obstructions. However, Section 130B(5)(a) states that no order shall be made under this section if the Highway Authority satisfy the court that the fact that the way obstructed is a highway within Section 130A2 is seriously disputed. Section 138(2) includes footpaths. Likewise, there is an established legal principle that if the status of the way is in serious dispute, the duty under Section 130 also does not apply. Specialist legal advice has been sought on the meaning of seriously disputed, which confirms the advice previously given to the committee that the alleged rights of way across Stoke Lodge are in serious dispute. This means the duty under Section 130 and the provisions of Section 137 do not apply and should not be relied upon. It is therefore recommended that, on the basis that the status of the alleged public rights of way are seriously disputed, no action be taken in respect of the Section 130A notices served on Bristol City Council, and the applicant be notified accordingly.
Thank you, Duncan. Dawn, without straying into the external legal advice, if we just keep it factual for the time being, could you give us the facts of what happened in Gaya? Who was Mr. Gaya? Why was he suing Lancashire County Council, and what was the position of Lancashire County Council?
Right, I've got a document I'm going to read from. I don't know if members, I've printed copies in case you'd like a copy to read from, because it's quite a lot of information and it might be easy to read. So, as Duncan has mentioned, Section 130 duty applies to highways. The Gaya judgment...
Sorry, Dawn, could you just explain, give me the facts first, because I think it's just useful to know what actually happened. Is that included in here? I don't want to stray into legal advice. I just like the facts to begin with. Who was Mr. Gaya? What was he trying to do? Just as an introduction, really, as to what the case, how the case worked, and what was the council's position. It's just useful to see how it reflects our situation. Okay. And then we can look at the legal stuff. But if we get into detailed legal stuff, we obviously might have to move into exempt session. So the facts would be good. Yeah, let's have the facts first, then into the legals. Yep. Is that all right?
Yes, that's fine. So, the facts of the Gaya case were the alleged rights of way were not on the definitive map. I think that the party who owned the land had erected fences, and Mr. Gaya then asked the council to protect the rights of way and to assert that they were public rights of way. The council held an inquiry. I should add that this was under a different statutory process. They didn't have applications for definitive map modification orders at that time, the process that we're now going through. So the council held an inquiry. They heard evidence from people alleging that there was a public right-of-way, and they heard evidence from people alleging that there wasn't a public right-of-way. The council decided that there wasn't sufficient information for them to conclude there was a public right-of-way, and held that it should be declared by the courts instead. And so they were not going to use their duty under what was Section 116, but is now Section 130 of the Highways Act. And Mr. Gaya took them to court to try and force them to use their Section 130 duty as it is now. And the court ruled that because there was a serious dispute, i.e. there was one side providing substantial evidence that there was a public right-of-way, and there was another party providing substantial evidence that there wasn't a public right-of-way, the court concluded because there was this serious dispute that the council did not have this duty to enforce the rights, because there wasn't, the rights of way weren't set out.
But the material difference, I guess, was Lancashire County Council, unlike Bristol City Council, did not support the rights of way in the same way that we voted on them here. So in a sense, the council's position is supportive of the rights of way. We don't dispute them, but they are disputed, but we don't dispute them. Whereas in Lancashire, they were a bit sort of, they hadn't actually endorsed them, had they? They hadn't approved them.
They didn't believe there was sufficient evidence either way.
No, okay, that's fine, that's clear. So we've got the facts. Are there any more facts, or is that enough?
That's it.
That's the facts. So on to the legal advice.
Yeah. So Section 130 duty applies to highways. The Gaya judgment, as we've just mentioned, established the legal principle that the Section 130 duty does not apply if there is a serious dispute, as to the status of the way, i.e. whether it is a highway or not. As established by Gaia, there is a serious dispute in circumstances where there is material evidence of some substance indicating the way is public and material evidence of some substance indicating the way is private. It is not necessary for such conflicting evidence to reach a specific standard of proof, such as 50-50, in order for there to be a serious dispute or for there not to be a serious dispute. Instead, there must simply be material evidence of some substance pointing in each direction. On the other hand, if the evidence in one direction is of no real substance, such as it amounts to a mere assertion or suggestion without supporting material evidence, that would not give rise to a serious dispute. Similarly, if there was irrefutable evidence that pointed one way, such as the way was recorded on the definitive map, then there would be no serious dispute. For clarity, the Gaia judgment did not establish that for there to be a serious dispute, the facts must be exactly the same as in Gaia. Gaia simply confirmed that if there was a serious dispute as to the status of a way, the Section 130 duty does not apply. Here, the Council resolved that on the balance of probabilities and based on the evidence presented, the public rights of way exist. However, that resolution was only the first step in the process of determining the status of the alleged public rights of way under the definitive map modification order application process. Following that resolution, the order was made and the statutory public consultation undertaken. That public consultation allows the public to make comments or submit objections to the Council's decision to make the order. 2 objections were submitted. As the objections were not withdrawn, the decision whether to confirm the order is now to be made by the Secretary of State. It is therefore a matter of fact that there is a dispute as to the status of the alleged footpaths. It will be for committee to consider whether the differing opinions of each party amount to a serious dispute based on the criteria I previously set out, and I've listed it again there, but I won't go through it again. Matters of relevance as to whether there is a serious dispute should include all the available evidence and submissions made in relation to the DMMO application to date, both in support of the application and in support of the 2 objections. Any other matters of relevance, including from the Village Green applications and the related litigation, are also relevant to consider whether it's a serious dispute. And for example, the recent High Court findings on the site's Village Green registration in relation to signage and statutory incompatibility are of relevance, given that those matters are also relevant to whether the use was as of right and whether the claimed public rights of way are capable of being dedicated as public footpaths. Again, for clarity, if the committee resolved that there is a serious dispute based on the guidance I've given and set out in the Gaia judgment, you are not changing the committee's original position. You will simply be acknowledging that there is a serious dispute that has emerged following consultation, in that the committee's position is that the rights of way exist, whereas other parties have the position that the rights of way do not exist. Both parties have material evidence of some substance that needs to be considered by the inspector before they make their final decision.
Thanks very much. And the focus there very clearly on dispute or serious dispute. So thank you for focusing on that. That's quite right. Right. So over to the... Oh, actually, I just wanted to ask about the process. Does everybody understand, on the committee, understand the process, what happens with these notices? Or do you want Duncan just to explain how the notices... Do you want to just explain a little bit what happens? So the notices... So if we run the hypothesis that we follow the recommendation and reject the notice, what happens next?
So by reject, you mean basically you follow the recommendation. Basically, we would then respond to the applicant of the Section 138 notice, where we have options to, we would reply what action we're going to take, and the legislation say what action we're going to take, if any. So in that situation, we would inform the applicant that we are not going to take any action to the 138 notices. We would also provide a short explanation as to why.
What happens if the applicant isn't happy? Do we end up in court?
The applicant could then apply to the Magistrates' Court, and then we would have to make an argument under Section 130B 5A, as I mentioned earlier on, as to why we think we shouldn't be taking action under the serious dispute.
So we would have to say it's a serious dispute. Okay. Have we had one of these before?
We have had Section 130A notices in the past. We get very, very few. I think the last one was probably around about 10 years ago.
Okay. I'm just hypothesising because I know nothing about the process. Okay, so the judge will then say, you haven't enforced because you're pleading serious dispute as per Gaia. But if he asks, what is the council's position? Do you support these public rights of way? We have to say, yes, we do, because we have supported them. Is that right? So we are very, very supportive. Are there lots of objections? Are there lots of support? So we've got hundreds of people supporting, and we do have some objections. So we do run a risk that the judge might not accept what we're saying. I don't know.
If we've concluded there's a serious dispute, we'll put that same evidence to the judge and then they will make their decision.
If we're asked the factual question, do we support the rights of way, as a council, we will say we certainly do, and would explain what's happened. Okay. Right, I'm going to throw this open now to the committee because they're itching. One caveat, if I may please, if we could start with general questions. Once you want to test the specific external legal advice, Nancy will be very clear, but please do interrupt us. Please use that, and we then will need to move. But if we start with general questions, we're okay here, and then the public will be happy. But you may want to test that external legal advice, in which case we will need to move. Don, the floor is yours.
Thank you, Chair. I think the situation is a little clearer than you have made out in many ways. You perhaps have hit the ball into the long grass somewhat, and I don't entirely agree with your advice at the beginning that we have to choose between one trip to court and another trip to court. I think that's not the best advice that Chair should give a regulatory committee, actually. It's quite simple. Doesn't involve the details of this Gaia case. What it involves, what the Gaia case makes clear, is that if there is a serious dispute, then we may not enforce legally. We're certainly in very serious legal problems if we do. Now, I don't think it gets any more serious than our decision having been referred to central government to be confirmed or not confirmed. That's about as serious as it gets. And as you yourself have said, we expect in a few weeks to hear from the Planning Inspectorate with their decision. I voted, obviously, to confirm these. It's a matter of record that we did. So I hope that the Inspectorate sees to agree with us. However, it'd be very, very foolish at this point to put further money into a risky thing when we expect a decision to come through soon anyway. Sorry, that wasn't really a question, but...
That's all right, Don, but I can respond to what you've said. My opening comments about litigation are from page 9 of our pack of papers. I'll read it out because there's obviously some confusion. What the officer report says is, and I was only reiterating the guidance from the officers, it should be noted that any enforcement action may be met by a challenge from Cottam School, resulting in further specialist legal resource being required. Not taking enforcement action may result in challenge for failing to carry out requirements of Section 130A notice and a request being made to Magistrates Court for an order to be made requiring enforcement action to be taken by Bristol City Council. So what I was trying to say is either way, we could end up in court. And that's actually from the officer report. That's what I'm trying to say.
Theoretically, that's correct. It's interesting that you chose to highlight it at the beginning.
Well, also to explain why there's legal privilege and why we might have to move into exempt session as well. And I think the public need to know why we might suddenly vacate this chamber. Abby.
Thank you. This is a very general question, but I guess I'd find it useful for context. I wondered, that 125-year lease that started in 2011, I was interested in what the terms of that lease were, and under what conditions the lease would be sort of broken if terms of the lease weren't met. So for example, I guess I'm thinking about what we've heard about, sort of trees with tree protection orders on them, and looking after those, and sort of loudspeakers that are going off sort of day and night. I'm wondering whether the terms of the lease cover any sort of those sorts of things, because as I understand it, those couldn't really be come into the PROW enforcement anyway.
I'm going to hand over very quickly either to Dawn or Nancy. I don't know who wants to talk about the lease.
I don't have any information about the lease.
So we don't have the lease. Anybody who can talk about the lease. So I think that's something perhaps we do need to provide. So we could perhaps provide an answer to Abby in writing afterwards about the lease. It's not directly relevant, but it's a question that a councillor has asked. That's why we'll take it up. Tim, I think you were next, but unless I missed.
Thank you, Chair. I just had a quick question, actually, based on the legal guidance. This may mean nothing, but I noticed the public rights-of-way are sometimes referred to as the alleged public rights-of-way. Yet the committee did meet, I think last November, and decided that the public rights-of-way existed. I remember at the time, I think they were referred to as alleged public rights-of-way at that meeting. Are they still legally alleged public rights-of-way? Are they now public rights-of-way or not yet on the definitive map?
No, until it's confirmed by the Secretary of State, they will still have the status of being alleged.
So just to double check that, and this may be a complete red herring, maybe of no relevance anyway, they remain alleged for what reason? Because this committee has found that they are public rights-of-way.
Yes, but the committee wasn't the final determiner. The final decision maker will be the Secretary of State. When you made the resolution and it went out to public consultation, if there had been no objections, then the committee would have been able to confirm the order themselves, and then they would no longer be alleged and they'd be put on the definitive map. But following the resolution, we've had the statutory consultation, and because there are objections and there is this dispute, the final decision will be made by the Secretary of State. So at the moment they're still alleged. Even though you have concluded, in your view, that on the balance of probabilities the rights of way exist, that final decision has to be made by the Secretary of State because of the objections.
So just to wrap that up, the public rights of way remain alleged until they enter onto the definitive map then?
Yes. Yes, that's correct. It doesn't mean that they can't be, and there can't be enforcement action against them. The question is whether there's a serious dispute as to whether they're a highway or not, which is what the situation we're in at the moment.
Okay, thank you.
Sorry, Christiane.
So from what I would clarify in my own mind, what we're trying to decide here is the difference between a dispute and a serious dispute, and where that threshold may or may not be. So in my mind, it cannot be, by definition, going to the inspector and being challenged, being serious, because there must be something below that. Is there something below going to the inspector that would be a dispute?
So the guidance that I set out previously from Gaia, which suggests if something is the seriousness of something. So if there's evidence in one direction which is of no real substance, such as mere assertion or suggestion without supporting material evidence, then it's not a serious dispute. Similarly, if there's irrefutable evidence that pointed one way, such as the way was recorded on the definitive map, then there would be no serious dispute. So I know we briefly discussed last time what would be considered a dispute and a serious dispute. So any objection, if we receive any objection, it has to go to the Secretary of State. Sometimes we've received objections on previous DMMO applications. We've received objections where the objection is just, I don't agree with this, but they don't back it up with evidence. Or it's on the basis of an objection which is not something that can't be taken into account. So it's about antisocial behaviour, which is of concern to the person, but it's not something that is taken into account in the consideration of a definitive map modification or application. In that instance, I think you could argue that it's not a serious dispute because it's not really, that argument is not really going to change the position of the council, their decision. If there is evidence that has some substance that has to be considered and points to a different direction to what the resolution of the council was, then it becomes more serious. And so that's the weighting that you have to consider.
As always, Christine, you've put your finger on what really is the heart of this matter. Is it a dispute or is it a serious dispute? But carry on, you've got more questions.
Yeah, it's just that from what I understood from what Councillor Alexander was saying is the fact that it's going to the inspector therefore makes it a serious dispute.
It certainly is a factor in the consideration of its seriousness. It's not the only factor, but it is one of the main factors. The fact that, well, the fact that it's going to the Secretary of State means it's a dispute. So with that is,
yeah.
And then you've got to consider the balancing of the substance of the evidence as to the seriousness of that dispute. So it's one of the factors, but it's not the only factor.
Okay, so sorry, I'll be quiet after that. On. So for example, then there are two. There's a named individual and there's an institution that are both bringing objections. So it would be considerably more serious if there were another 5 or 6 individuals and another couple of institutions.
No, it's not the number of objections, it's the content of the objection and the evidence that they're providing or the issues that are being raised that need to be considered.
Ah, okay, thanks, right.
And that'll be a judgment call. Ed, far away.
Thanks very much. Firstly, just to say, considering some of the events that have taken place on the site in recent weeks and distant years, I think it was entirely reasonable for Councillor Finch to ask for a copy of the lease. I think that's an entirely reasonable course of action. On this, I believe it is. Building on Councillor Townsend's question, where we talk about this idea of the serious dispute, and we talk about the evidence provided from the objectors that the way is private, please could you direct us to the specific points of evidence within that objection that therefore have helped you reach the judgment that this is a serious dispute rather than just a plain dispute?
Nancy will have a quick word because
it's for the committee to decide whether it's a serious dispute. So you have to look at the evidence that has been put forward and then decide on the basis of the advice that you've been given whether you consider that to be a serious dispute.
Okay, so in that spirit, have we been supplied with a copy of the objection itself?
It hasn't been supplied with the papers for this meeting. However, you would have been provided with them in the past when they first came before it went to planning inspector. I believe is the case.
Could we be directed to the previous agenda in which this features so we can look at, because I don't really see how we could come to a judgment on the seriousness of a dispute without that crucial piece of evidence being in front of us now.
The objections wouldn't have come to a committee meeting. They would have come direct to officers.
Could you direct me to which specific committee meeting so I can go and look that up right now and read it?
As I said, I don't think the objections wouldn't have come to a committee meeting. When the objections came in, they would come into officers. They may have been shared with committee. I'd have to go back and check that. I don't know now whether they would have been.
Okay, so if we're being asked to make an objective judgment on this, yet we don't have the piece of evidence that will help us determine whether the dispute is serious or not, how can we make that judgment?
I can confirm that the objection from Cotton School was part of the submissions when you made the original resolution. There was a few amendments to their objection that was submitted as part of the statutory consultation, but it formed part of the...
Okay, so that should be included within our pact from the November 2024 meeting. Okay, I'll go look at that now and see if I can locate it. Thank you.
Okay, and we took it into account when we came to our decision to actually establish the public rights of way, because so we read it, but didn't think it was sufficiently material dissuade us. Kaz.
Thank you for that, Chair. And yes, I've actually got the papers from the last meeting where we discussed this in front of me, sort of pages 809 onwards, and it kind of outlines some of the objections from Cotton School. And on the balance of probabilities at the time, we made a decision that they were put rights away here, but you could see the objections clearly laid out, and there were a number of items listed. So, to my mind, that suggests a serious dispute. My question would be, can I also take into account whether a serious dispute is on the basis of the length of time this has been going on for, or is it just on the basis of what would be on this sort of example in front of me here?
Yeah, the time frame, unfortunately, is not something that's relevant for your consideration as to whether it's a serious dispute. Or the matters, and if there's relevant information in terms of the various matters that have happened, the TVG, etc., that might be of relevance, but the time frame itself is not something that's relevant.
Abby?
This is sort of a clarifying question. So it says on the agenda, it's on page 8, point 18. The further this further notice. Oh yeah, so it's the point 17 actually. If the obstruction remains, the complainant can serve a further notice on the Highway Authority stating that they intend to apply to the Magistrates Court. So it sounds like whether or not we do, whether or not we serve, we take forward enforcement action, if the obstructions remain, it could still go to Magistrates Court. Is that correct?
Yes, if the applicant wishes to progress it, they can make an application to the Magistrates Court.
Thank you.
Sorry, that's if we don't enforce, then they can progress to a Magistrates Court.
So, but in this, so it says if in here it says if the obstruction remains. So it sounds that I guess presumably there is a possibility that we take enforcement action which is unsuccessful. I guess that's what I'm asking is in the case of unsuccessful enforcement action.
Well, then it's for the council to carry out further enforcement action.
Okay, but if by 2 months period from the initial notice being served, which I make that the 1st of December, I imagine it might take more than 2 months. It sounds like from what I'm reading in point 17 and 18 here, that at that point it could be escalated to Magistrates Court if the original person who issued the notice decided to do that.
No, I don't think that's quite right. I think if the committee decides that enforcement action should be taken, then it's for the council to proceed with that and take all necessary steps to make sure that that's done. It would only be if the council, if the committee decided not to enforce, then the applicant has another remedy to go to the Magistrates Court, so the Magistrates Court can then decide, can look at the decision that was made by this committee. So if the committee decides to enforce, then it's up to the council to proceed and follow that through and make any applications necessary. Does that answer your question? So
it does answer it. Just to me, it seems to go against what it says in point 17 and 18, which is if the obstruction remains, the complainant can serve a further notice on the Highway Authority stating that they intend to apply to the Magistrates Court for an order requiring the Highways Authority to take steps to remove the obstruction. This further notice cannot be served before the end of 2 months, beginning with the date on which the original notice was served on the Highways Authority. Does that make sense why those two things don't quite align?
Yeah, so I think it's the applicant has the right to then apply to the magistrates' courts if the council haven't done anything. I think if the council has started enforcement action, but there is unsuccessful, then it's for the council to proceed with that and pursue it. It's only if the council haven't done anything that the applicant can then go to the magistrates' court to try and force the council to do something. So,
it makes sense, it's just not
clear.
Ed, come on.
Thank you. I want to express my thanks first to Councillor Self for citing page 809. That was incredibly useful and has saved me oodles of time. I've had a look through this. This is for context for the gallery. This is a letter from Goodnow Ring solicitors that was provided in the packs to the meeting in November 2024, where we this committee alleged that the rights of way did exist. So there were a series of points in that letter from the solicitors. The pertinent part is probably part 6 in my judgment. So I'll just briefly read it out. The obviously important considerations from the previous Village Green decisions are A, the consistent conclusion that members of the public did not use the land in the nature of a right-of-way, rather wandered all over the land in the nature of a Village Green right, and B, the signs on the land rendered the use by the public contentious and not as of right. Now, as we know, a decision was taken by a court on the previous Village Green decision, so 6A, in my view, can't be taken into consideration. And 6B, just to re-clarify a point that I believe Councillor Kent raised in the meeting back in November, apologies if I misattributed that to him. The signs in question there, as I understand it, they went up after 1985, and therefore after the period in which we took into consideration as to whether it was a right-of-way or not. Can I just confirm that's correct?
I believe that is correct, but Dawn wants to comment. It's different time periods. So for public rights of way, you can go way back in time. You can't do that with TVGs.
Yes, that's right. So in any case, those are the only points of substance that relate to the use of the right of way. All of the other points now relate to the timeliness of communications, essentially, from what I can tell. So there is nothing in that document that I can see that would qualify as a live, serious dispute.
And indeed, we did take into account that objection when we came to our decision. Any more questions? Happy, far away.
Sorry, I have a couple more, but I know I've spoken a lot. I'll try and make them quick. So one question I had was, I guess, if we leave aside the issue of whether they're disputed or seriously disputed, because it's the first time I've come across one of these Section 130 notices.
Same for me, Abby. I've not.
Yeah, I'm interested in, what action we would be taking if there was if it was a clear case. But I guess especially I'm thinking, because at the moment the gates are open, would we be widening at point H where it's narrowed? Would we be removing the gate completely at point H, and then at point E where it's got the gate that's locked and then a side gate, would we be sort of removing one of those gates? How would that look, and how would that process happen?
If there was, if you find that there is to be no serious dispute, as you said, and this was a 138 notice served on us, then, and we looked into it and then basically decided, yes, this is an obstructed right-of-way or an alleged right-of-way, then we would serve generally a Section 143 notice on the person or the landowner or the person obstructing that right-of-way, requiring them to remove it. As for whether we would remove it, certainly with regards to gates, the gates should be, the gate shouldn't exist, basically. So we'd ask for the gates to be removed. As for the width, there are obstructions, things like staggered barriers and rights of way that can impede width, etc. So we would have to make a decision as rights of way officers as to whether or not we would see that as a limitation, or whether we would then ask for the actual right of way to be open to the full width of 2 metres, because it might be that on a right of way down between houses, there might be a tree growing. We're not going to remove the tree to maintain 2 metres. Of course, it's different at Stoke Lodge. So we'd make the decision then as to what we would expect to be opened up. We'd make that clear in any enforcement action in any enforcement letter that we put to the landowner.
Thank you, that's clear, yeah, because I wasn't sure about gates, but that makes it really clear that lockable gates are not, yeah, okay. And then I guess my other question is, so it references in the papers the fact that there have been 2 objections, but the only one that I saw actually described was one from Cottam School. I wondered if you can share anything about the other objection, and also I'd be interested to know, is there new evidence in either of those objections that we didn't consider when we came to the decision to approve the rights of way?
I haven't got the second objection to hand. I'm not sure whether one of my colleagues would like to speak about that second objection. And just, we're just going to bring it up.
There wasn't any new information or new evidence that wasn't previously looked at in the November committee, so it's nothing. Yeah, it's just from a private individual on their behalf. Sorry, did that answer?
Yes.
Are there any other questions while we're... Tim?
Hi, thanks. I mean, ultimately this comes down to the interpretation of what serious dispute is, and a lot of this, of course, is laid out in Gaia, which is pretty much the only real written source of serious dispute. So I guess my question here is, now this is a bit technical, and there are 3 judges that actually give their opinion on Gaia from how I read this. And there is an interesting element in the third judge's opinion, because obviously he hasn't got a lot to say, because the first judge and the second judge have really taken up the space. I do note something really important, actually, which I think is an important point about Gaia, because when you look at Gaia, there is a fundamental difference in the sense that the council does not accept that there's a public right of way. So you could sort of see an argument there that the council itself was in serious dispute, and I take councils as being serious bodies. But I note in what Sir David Cairns says, and it is quite short, and I want to read this out, and I want to sort of see if your interpretation is the same. He says, I agree that this appeal should be dismissed for the reasons which have been given in the 2 judgments which have already been delivered. I will add a few words of my own out of respect to the argument which was addressed to the court by Mr. Bloom. I think he was the solicitor for one of the sides, I can't remember which. So in this, he says, the County Council's duty under section 116 of the Highways Act 59, as amended, can in my view only come into play if the Highway Authority are satisfied that there is a public right of way which is threatened. So he's picked up very clearly there on the issue that the council have not accepted that it's a highway, and he has added that as a 3rd additional opinion. I think my point is he's added that on top of the words of serious dispute. So I read that as he's not saying that serious dispute is defined solely because the council are disputing it, but there is a greater, wider dispute. Would that be reasonable? Because I've got to say, when I first read Gaia, it's a bit muddy and not always clear. I read it that a lot of this was down to the fact that the council themselves did not accept the line, but now actually having read that 3rd judgment, he very clearly feels that he needs to define additional information on top of what the other 2 judges have said, and on top of what they have already defined as being a serious dispute. Does that make any sense, what I've just said?
So the legal principle is the serious dispute point. The comments by the third judge is what's known as obiter dicta. It's not, it's information that's useful, but it doesn't form part of the legal principle. The legal principle is the guidance that you need to consider. The facts and the also ran judgments, they're not relevant. Nancy, do you agree?
That's just his thoughts. I guess what I am trying to, I mean, like many people, I'm struggling of where is the line of serious dispute. I mean, from his thoughts there, he seems to sort of think that serious dispute is not just down to whether the council is disputing it. He seems to be, I mean, in the sense, the fact that he is saying the council didn't agree that this was a footpath. I mean, he seemed to think he wanted to specifically point that out.
In that case, there was a serious dispute because there was one side was saying there was a public right-of-way and another side saying there wasn't a public right-of-way, and the council couldn't make a decision. So there was a serious dispute, so they couldn't make the decision. In this case, there's a serious dispute because the council have resolved that there are for public rights-of-way, but following the public consultation, which is a statutory process, there are objections, and so there is a dispute. So there's a dispute in each case. It just follows a slightly different format.
Thank you.
And it's a matter of our judgment as to whether we judge it to be a serious dispute or a dispute. There clearly is a dispute because there's a challenge, but is that a serious dispute? And that's the nub of the matter. I think Christine sort of put a finger on it at our first meeting, actually, and nothing fundamentally has changed. I was just going to ask, I don't think we know the answers. The old process, was it just the council that made the decision on rights of way?
Yeah, I'm not 100%, but I think there was no set process for a council to make a decision on a public right-of-way. They could seek a court declaration as to whether there's a right-of-way, and that's what's referred to in Gaia. But there wasn't the process that there is now about a person can apply for footpaths to be put on a definitive map. I don't know if Duncan knows. No.
You weren't there in 1959.
Members, can I just make another point in relation to the advice that you've been given? You've had advice from Dawn as a subject matter expert, but you've also had council's advice, external advice, and you need to take into consideration the advice that you've been given in that document that does go into council's opinion in relation to what is a serious dispute. So I'm not saying that you necessarily have to go into that now, but you've had access to that document. You will have read it. If you want to go into that further, then we will need to go into exempt session. But I do need to remind you that that is advice that is available to you and that you should take into consideration. So it's supplemental to the advice that you've been given by Dawn.
And all members can confirm they've received it? Yes. Cass.
Thanks, Chair. I just wanted to explore the issue of this word serious, and whether it's relevant or not, because you have a dispute or a serious dispute and no dispute. Is the fact that the word serious in there of any importance? And is this sort of middle ground of dispute something that we need to take into consideration in our thinking?
Yeah, sorry. I mean, we've advised on what you need to consider for it to be serious, and also in the advice that's been given to you as well sets out criteria for consideration.
The advice from the barrister, sorry.
I think it's covered in Dawn's notes, actually. Good idea to note. Sorry, Don.
Thank you. We ought to take seriously council's advice because we paid enough money for it, for one thing. So the question now is whether we can wait for a definitive decision, a few weeks, a few months from the government, or whether this administration's got yet more money to burn on barristers. That's what it comes down to. My advice would be to wait until then we will have a clear decision from the central government. They have every right to make that decision, whether we like it or not. And then what happens then will follow through automatically, enforcement or whatever. And we'll be on solid ground for doing it. But we spent a lot of money so far that this administration hasn't got. And as a councillor for a ward like Avonmouth and Lawrence Weston, I've got many, many other priorities for that money.
It's exempt. Oh, correct. Okay, so we need to move into exempt section. Any non-exempt questions still outstanding?
Once questions were finished, were you going to move to a vote, or were you going to open up to a quick debate? That was my only real question.
I think Abby might have an exempt question, so I'm quite happy to open it to debate if you want me to do that first, or...
I mean, if I'm the only
question, and we'll see if it is exempt. Okay.
If I'm the only person, yeah, I could try and...
Try the question, just
okay.
See what the opinion is.
Councillor, can I just say, if you're going to specifically read out parts of the advice,
yes,
then
I realise
we would have to do that in exempt session.
Yes, which is what I was going to do, but I will see if I can ask without doing that. I think I can ask this one. So from what I understand with the Gaia case, it's a case where the local authority decided not to enforce, and then they were justifying that to the court, and so I guess what I'm interested in, so that sets a precedent that if we were to decide not to enforce, we would have a legal argument to make based on that case. What doesn't necessarily follow to my mind is that we could be penalised for choosing choosing to enforce. Does that make sense? To me, there's a difference between having a line that we could use to justify choosing not to enforce and it being something that can be used to penalise us for choosing to enforce.
Yeah, I think it's it comes down to the fact that the Section 130 duty doesn't apply if there's a serious dispute, so the power isn't there. So you can't enforce because it's not a highway under the Act, so you just don't have the power to enforce.
Because of a serious dispute?
Yes.
If we deem it to be.
So for the very reason that they made that argument as a reason not to enforce, that argument then applies in all cases, whether the decision is taken to enforce or not.
Yes, so they were saying because it's not clear that it is a highway and something that we have power over, we can't then enforce. So because there's a serious dispute as to whether it's a highway or not. So it's the status of the highway that's in question. Is it a highway under the Highway Act and do the powers apply? Or is there a serious dispute as to whether there's a highway, that it's a highway under the Highways Act, so that the powers don't yet apply? That's the situation. Do the powers apply or do they not?
Do you want to open it to wider debate? But obviously not treading on the exempt.
Okay, thank you, Chair. I mean, this is always going to be a difficult legal decision, as nearly everything that comes to this committee is. And often what we find is the legal precedents themselves are not always as clear as we would like them to be. I think that weighing up the facts and the evidence and the advice we've been given, I do believe that there is an issue
but without any doubt, dispute, but also an issue of serious dispute. And I want to lay out why I think that. First, I can understand that will be disappointing for those people who've come, but the majority of people who've come along here today. But we're here not deciding if these are public footpaths. We've already made that decision. They are public footpaths as far as this committee is concerned. Our only question here today is whether or not, under the powers bestowed upon us, do we actually have the right to enforce what we already know or believe to be true. And I don't believe we do, based on what is in Gaia, but also that additional legal advice we have been seeking and have received. I want to sort of clarify that, and that is because there have been additional objections, and I think it has where it's going to the Secretary of State, so it's going through a formal process. I think that is reasonable for us to consider that to be an issue of serious dispute. I am aware that, you know, a serious dispute doesn't have to be like a 50-50 case. Evidence doesn't have to be balanced. And obviously, if it's completely erroneous, we could potentially ignore it. But I don't think it is erroneous. I don't accept the position of Cottam School put forward here today. I don't accept actually that there is a statutory incompatibility, because what they have failed to understand is those public footpaths existed even before a child kicked a football on the field. I'm sorry you didn't know they were there, we didn't know they were there, but the public had already exerted their rights, and that's what they proved to our committee. But I can also accept that there are probably well-paid lawyers arguing against that. And I think that does present us with, in this case, an issue of serious dispute. Am I absolutely certain of that position? No, I'm not. As you know, Chair, I do have a bit of a saying, and my saying is, it is an absolute fact that 50% of all lawyers are wrong. It's proved every single minute in court. But I think we've got to follow good, clear legal advice we've been given here today, and so I will be voting with the recommendation.
Thank you. Carol, did you want to speak? And then Ed.
Yeah, just to sum up then, what we've heard today is that these are alleged public rights of way. As a committee, we made the decision that we feel there should be public rights of way, but there is a process that's going through, and they have been advertised and objections raised. We've heard that the objections are very similar to what was in the last paper when we looked at the public rights of way, and there were 6 points laid out in terms of objections there. I'm not saying that every single one of those will now apply, but the fact there were 6 points there at the time suggests to me that this is a serious dispute. Also, I'm not a counsel, a barrister, and I'm quite interested to hear what Tim said about that one. But I am very much minded that we did pay for advice from a barrister for this. That advice is in front of us. His suggestion is there is a serious dispute, and I am minded myself to go along with his advice for those reasons.
Thank you, Gaz. Ed.
Thanks very much. I'm concerned that quite a lot of the rhetoric this afternoon has been around the prospect of legal threats that have been around almost weight of advice being taken on the basis that either A, we've paid for it, or B, we might be, this council might be asked to pay for it later through the form of some kind of legal assessment. I don't think this committee should be making decisions based on that kind of fear or further, to be frank. It should be based on the matter at hand in front of us and exclusively that matter of hand. And when it comes to the matter of hand, I'm pleased that we were able to review that previous evidence with legacy objections today, so thank you very much for guidance from officers and members alike on being able to find that and establish that. I do understand there is significant nuance around the idea of dispute and serious dispute, and it will probably be of surprise those outside the public gallery that we managed to spend 90 minutes discussing such detailed terminology, but that is what this committee is for, and it is absolutely necessary. The view I have to take is that I have to be moved to believe, to believe that it is definitely a serious dispute. I have not been moved to that point, therefore I can't personally conclude that it is a serious dispute, and therefore I would feel obliged to vote in favour of enforcement action being taken.
Thank you, Ed. Does anybody else want to speak, or are we happy to move to a vote? I mean, are we happy to move to a vote? Okay. So, the motion... Sorry.
Sorry, I do just want to say that it would have been really, really helpful to get those, to be able to see those objections within the papers for this. I know that one of them was similar in wording to one that we'd seen before, but I think being able to actually understand the wording of those objections, that because we've been told that what makes it serious is the content of the objections, it is very hard for us to determine whether it's serious without seeing the content of those. So I guess for future, I know that we can't postpone this because we've got a deadline, but for future having that, I would say is sort of essential, really.
Indeed, we've noted that point. Don?
It seems to me that it's perfectly reasonable for a landowner to object to the decision of this committee and to have recourse in process to the inspectorate, i.e. central government. For us to say we have made a decision amongst us councillors here, therefore now we send in the enforcement people to take down your fence, quite frightens me. Actually, where does that leave process? Where does that leave process?
Does anyone else want to say anything before we move to vote or not? Don, Don, are you happy to move the report as it stands? And do we have a second of the
Very happy, Chair.
Seconding? Ellie seconds. Okay. So those in favour of the report, which recommends no action on the basis that we have a serious dispute, would they like to raise their hands? Those in support. Okay. And those against? And any abstentions? Okay. The motion is carried.
Thank you very much, everybody.
Thanks everybody for your time. Members, thank you for coming to an EGM. And making the time to come. Thank you very much.
Thank you.